Here. We want to get into all of this right now. We're going to do that with our friend, legal analyst Neama Rahmani. He joins me. Neama, good to see you. Hope you had a good Memorial Day weekend, but we got to get right to it. And this is so interesting to me that the prosecution wanted a lot of time, 4 to 4.5 hours to lay out their case in closings. Why do you think they did that? And was it necessary, in your view, having followed kind of the back and forth today? I mean, the defense only needed, they said, about 2 hours, and then they ended. But the prosecution is still going as we speak, Neama.
Andrew, I don't know why they're still going. Lawyers like to talk. Some of them bill hourly. Prosecutors don't. But they're really spending too much time on this case. This isn't a multi-defendant, complex case. Obviously, there's a political layer on top of this. There are some convoluted legal arguments with respect to the election fraud and the campaign finance violations. But if I were the prosecution, I would direct their jury's attention to what really matters, which is those business records. They're spending way too much time talking about Michael Cohen. That actually plays into what the defense is trying to do, put Cohen on trial. So I agree with you. We should have wrapped this up some time ago. The jurors seem to be paying attention by all accounts, but I mean, it's 8 p.m. Eastern almost, and time to put this to bed.
So just having followed some of the analysis from some of our Fox legal analysts as well, some have said that this is in the defense's favor, that the jury's going to be exhausted after this. Is that accurate? I mean, does the defense get an upper hand after the jury has to be put through hours of closing arguments by the prosecution? Would you agree?
Well, it's yes and no. I mean, there is an advantage to go last. And most states, including the federal system, the prosecution goes first, then the defense goes, and then the prosecution actually gets a rebuttal. So a short closing at the end. In New York, the defense goes first and the prosecution goes second. So they have to save everything for the end. And, you know, it really depends on the jurors. They seem to be alert. They seem to be paying attention. But the conventional wisdom in a case like this is less and more, pound and focused on your strengths. You don't have to address every single argument that the defense has made, which I think the prosecution is doing here.
You know, Neama, this was news to me about the order of the closing arguments, because, you know, it seemed like that's de rigueur, that the prosecution always goes first, then the defense, then the prosecution rebuts, but not New York, like you just said. I mean, Donald Trump weighed in on that order on Truth Social just last night. He said this: "Why is the corrupt government allowed to make the final argument in the case against me? Why can't the defense go last? Big advantage, very unfair witch hunt, DJT." Of course, that's par for the course for the former president. But, you know, does he have a point, so to speak?
No, because otherwise the deck is clearly stacked in his favor. And this is why the prosecution has a burden of proving each element of every count beyond a reasonable doubt. The higher standard in the law. This isn't preponderance of the evidence was used in a civil case, slightly more likely than not, 51%, or even clear and convincing, which is what the government needs to take your children away from you. This is beyond any reasonable doubt. And the prosecution has to get 12 out of 12 jurors, a unanimous verdict. We've talked about this a lot. If Donald Trump can even convince one juror, and it's 11-1 or 10-2, that hangs the entire panel and you get a mistrial. Again, you can contrast that to civil cases. So because of those two advantages in the defense's favor, and really it's to protect a criminal defendant's constitutional right. And, you know, everyone learns in first day of law school that there's a famous British Justice Blackstone, that said it's better that 10 guilty men go free than one innocent person suffer. And that's why we have the system we do. So really the only advantage the prosecution gets is they get to go last because they do have this burden.
You know, let's talk about what the defense said in their closings today. Todd Blanche, of course, the lead defense attorney for Trump, looked at the jury, according to our pool notes inside the courtroom, and said that Trump could go to jail if convicted. Now, Judge Juan Merchan called that comment, quote unquote, outrageous. What was so out of bounds about that, Neama?
It really is outrageous, Andrew, and this is why. As an attorney in a criminal case, you are not to comment on the potential sentence. Juries decide whether someone is guilty or not guilty, or guilt and innocent. Judges impose a sentence that's fair and reasonable and just under the law. So when you're a prosecutor or you're a defense attorney, you are not to comment on jail, prison, the potential sentence. Everyone knows this. Todd Blanche knows this. He was a prosecutor for years. So that comment was outrageous. It was out of bounds. He should know better. He tried to sneak it in to get some sympathy for the former president.
Oh, interesting. So, which I thought was interesting today as well, Alvin Bragg, the DA, he was in the courtroom. He hasn't been in the courtroom each and every day, but he came for closings today as well. You know, it does seem like, and I have to remind the viewers constantly, you know, the prosecution is still doing their closings right now. They have about 10 minutes left before they're going to go home. But it seemed like the majority of the closings from the prosecution centered on these, you know, in-kind contributions to the 2016 campaign. I want to ask you this. I don't know if I've asked you this before. What is the campaign finance violation that would amount to a felony? Like, what statute was violated that showed that this violated campaign finance laws, which in kind may have helped Donald Trump win the 2016 election? I mean, the burden the prosecution has of saying by suppressing the Stormy Daniels story, by the public not knowing about it, that would have helped Trump or sealed the presidency for Trump. I mean, that is such a burden, is it not? And have they gotten anywhere close to that?
That is their burden, and frankly, that is the most difficult part of the state's case. And they're making two separate arguments. There is a New York law that generally talks about election fraud, so that's one angle that they're taking, that by covering up these hush money payments, they were misleading voters, and that amounts to election fraud. So those jury instructions tomorrow, they're going to be critical because we've talked about it at length. The lawyers on the jury, they're going to sort through those jury instructions. The other argument, the campaign finance one, again, convoluted argument, but really when I was a prosecutor and I did election law, one of the first things you learn is something is something. And that really makes no sense. But really, a lot of people who handle election law, they will believe and they will argue, and there is some legal support for this, that anything that benefits the campaign is an in-kind campaign contribution. This came up in the John Edwards prosecution. This came up with Hillary Clinton, some of the benefits that she was receiving, the Steele dossier and some of the opposition research. Again, difficult argument, a convoluted one. I don't know if the prosecution has gotten there. I think this is the biggest weakness in their case. And I think that they might be trying to pigeonhole these misdemeanor violations and make them felonies on this basis, because for everyone who hasn't been watching us talk about this issue every day that we've been covering the trial, under New York law, false business records are just a misdemeanor unless they're in furtherance of or to cover up another crime. That's what we're trying to talk about, election fraud and campaign finance violations, even though we typically would not be. But one other important point, Andrew, we've talked about, even if Trump is convicted of felonies, I firmly believe that he will not be sentenced to jail or prison under any circumstances. They're just Class E felonies under New York law. So everyone talks about the maximum sentence of 4 years in prison, but it's not going to happen. And that's why what Todd Blanche said was so inappropriate, because he knows better.
Okay, so Neama, Andy McCarthy, the former federal prosecutor, on this, you know, what seems like a very expansive definition of a campaign finance violation and an in-kind contribution to a campaign. He said Alvin Bragg has made up his own version of federal campaign finance law in which any expense which is intended to influence the outcome of the election, no matter whether the expense would have existed independent of the campaign, is a campaign expenditure that triggers reporting requirements. What do you think about that? Is that legitimate?
It's a very broad reading, and typically these cases are not brought stateside when you're dealing with a federal candidate. And under federal election law and campaign finance law, there is that willfulness requirement. This is what some of the legal analysts have been talking about. So a lot of discussion has been around the jury instructions, and there's different types of intent, right? One is knowingly. Knowingly just means you know what you're doing. You don't have to know whether it's right or wrong or it breaks the law. But if something has a willfulness requirement, and typically these types of federal campaign finance violations do have a willfulness requirement, which means that not only have to know what you're doing, but you have to know that it violates the law. So a lot of folks think that's why the feds didn't charge Donald Trump with this violation. Of course, there's also the public policy issues as well, charging a former president. And that's why people think that maybe that's why just Cohen was charged by the feds, because federal prosecutors, the Department of Justice, did not think that they could prove that willfulness that's required on the federal side.
Okay, what about what Todd Blanche says about influencing an election? He says it happens all the time. He says that's democracy. He says candidates try to suppress embarrassing information in the stories about them while they're running for office, and that has happened from time immemorial. What's different about this?
It's frankly a good argument by Todd Blanche, and we've talked about it all day, every day, and people are making predictions, and it's impossible to know what's going to happen in this case. There's such a political layer over it. These legal arguments are hard to decipher. There's not a lot of precedent for it. Even if Trump is convicted, I think he's got good arguments on appeal with respect to the election influencing and the campaign finance violations. That's why I think if you forced me to predict today, I think the state has proved that the business records were false, and they've proven the misdemeanor violations. I don't think, and I'm not sure, that they've gotten to prove that they are felonies beyond a reasonable doubt.
Okay. So say that is operative and that is the case, that's the conclusion of this. Can that stand? I mean, can you have a resolution to these 34 charges against the former president just be misdemeanors and not felonies? Or does something technically get hicked up here? I mean, because that is the, basically motive of Alvin Bragg. He wants to elevate this to a felony, and he's done so in the charging. But if the jury says, these just look like misdemeanors, is that it?
That's it, Andrew, and there's a very real possibility that happens. If you kind of look at the possible scenarios, obviously the jury can acquit. I think it's unlikely we get a 12 out of 12 not guilty. The second is obviously a hung jury where, because of the political nature or the evidence or just the difficult legal issues in this case, the jurors aren't able to come to a resolution. And I think Judge Juan Merchan will let them deliberate through next week. When they come back and say they're hopelessly deadlocked, then he's going to read them an instruction, an Allen charge, send them back into that deliberation room. But they come back and say, we can't reach a verdict, it's going to mistrial, and we'll have to start this whole thing over, which probably won't happen if Trump is reelected. And maybe not happen at all if other more serious trials go forward if Trump is not reelected. But then you have the possibility that I mentioned, really the misdemeanor count, that the jury says, I believe that these business records were fraudulent. Donald Trump knew about them. Those are his signatures on the checks. That's his recording talking about Karen McDougal. But I'm not sure that this was done for a political reason or related to the election or a campaign reason. I thought he was just trying to protect his family from embarrassment. Or really, we just don't know. In which case, maybe you'll get a bunch of misdemeanor convictions. And really the question then is, was this all worth it to prosecute a former president for misdemeanor violations of New York law? I think everyone would deem that a failure for the prosecution.
I know, that was my question too. If the jury just renders him guilty on 34 misdemeanor counts, he's the former president of the United States, he could be president again. That seems like a pretty long shot by the prosecution to bring, such a case. I mean, if you're the prosecution, you want to get your defendant on any felony that you bring against them. I mean, you want them to have the maximum punitive measure here. One of the prosecutors, though, Neama, when we talk about the business records questions specifically, Steinglass is the prosecutor's last name, says that calling a payoff to Stormy Daniels the retainer, quote unquote, a retainer in Cohen's records is a false record, including, for example, that a payment to a lawyer can never be a retainer if you're paying the lawyer money other than fees that arise out of legal transactions. That seems pretty straightforward here. I mean, when the jury listens to that on that question, is that pretty black and white, cut and dry?
In my opinion, yes. We talked about the defense and Todd Blanche's good argument related to the campaign finance issue or the election issue. But I don't think the defense had a good argument on the false business records. I think they really swung for the fences to say that the records were not actually false, that there was a verbal retainer, even though maybe under New York law, a written one is required. We'll see what the judge says about that during instructions tomorrow. I think the defense made a mistake. They should have taken the position that Trump didn't have the knowledge or the intent, and someone in the accounting department erroneously, even though these were reimbursements to Michael Cohen, accounted for them as legal expenses. But they took the position that these records weren't false at all, that there were actually legal services rendered. And because Michael Cohen was Donald Trump's attorney, Trump was paying him $35,000 a month. I don't think that's particularly believable. And I agree with you, Andrew. I think Josh Steinclass has a very good argument with respect to the falsity of those records.
All right, Neama, we're approaching the top of the hour. We have our live picture outside of the courtroom. Caroline Elliott there outside told us about 30 minutes ago that Judge Juan Merchan, he was cutting off closings at 8 o'clock Eastern, which is in about 15 seconds. So we might possibly see some of the stakeholders in the room leave the room. We don't know whether or not the former president will speak. No doubt it's been a long day for everyone in there, Neama. You know, the jury. Let's talk about the jury. It's been a long day for them. They will presumably start deliberating tomorrow, and the length of their deliberations is a pretty good indication of how this is going to go, is it not?
No question.
All right, there is the former president, Neama, with a fist pump to the press outside. You see some of his children and in-laws there walking out of the courtroom. You also see some of his campaign advisors as well. There's Susie Wiles and Boris Epshteyn with the campaign. All right, so it seems like, and my producers can give me this information, that closings are over for the day officially now that the former president has left the building. There's Todd Blanche, of course. There's Emil Bove and so many others. So, Neama, today is done, day one of closing arguments. Let's get back to the jury question I just asked, but what a marathon of a day, is it not?
No question. Now, this is just a rule of thumb, but generally speaking, Andrew, jurors tend to deliberate 1 hour for each day of witness testimony. Now, obviously, this is a case unlike any other. But my prediction, at least in terms of timing, if we are going to get a guilty verdict, it's probably going to be Thursday, no later than Friday. There's a lot of pressure on jurors. They're ordinary people to get those verdicts in before the weekend. If deliberations continue into next week, we are looking at the very real possibility of a hung jury. So that's my prediction in terms of timing and deliberation. If we get a verdict tomorrow, a quick verdict, very likely a guilty verdict, and likely on all counts.
I mean, this is just also fascinating. You know, we just have to put into perspective here, Neama, this has never happened before with a former American president. And so what we have been discussing for, what, almost the last year and a half, we might get a resolution tomorrow, later this week, on this very momentous question and occasion of whether or not the Republican frontrunner for the nomination, the presumptive nominee, you know, might after this week be a convicted felon. I mean, that's a historic question, and we'll get an answer on it, won't we?
We will, and, you know, I don't mean to put this lightly. You're right, we are watching American history, but American history will be made by 12 strangers who couldn't get out of jury duty. That is our criminal justice system. So I'm a big believer in our jury system, but jurors are notoriously unpredictable, especially in a case like this with so many different political and legal layers. It's going to be fascinating to see what they come back with.
All right, Neama Rahmani, as always, can't thank you enough. I think we'll be talking a lot this week, Neama. Thanks.
Thanks, Andrew.